AI is going to be the most disruptive technology going forward. 2001, when I worked with Shah Rukh for his film Ashoka, or Amir with his film Dil Chahta Hai and Lagan, and
Law is ultimately made by the people to govern the people and be with the people.
process of training is equivalent to a human buying a book and reading it and then regurgitating material. But I think the key there is buying a book. What is this, Mr. Lall? You foreigners have taken our basmati, this, that, you Americans this, you Americans that, you steal everything.
Artificial intelligence has become a part of our daily lives. However, big tech like OpenAI, Meta, Google, Gemini, X have all been accused of using copyrighted materials to train their models. One of the key cases argued before the courts is being argued by a guest. Fierce, fit, and fabulously witty, senior advocate Shri Chander Lall. He was previously the head of the well-known firm Lall and Sethi. He has argued a galaxy of landmark cases before the Honorable Supreme Court, Honorable Delhi High Court, and various forums, shaping the very contours of our IP jurisprudence. Beyond the courtroom, he practically holds the trademark on adventure sports. Today, it's a privilege to invite the maestro himself. How are you, sir?
Very well. Thank you very much for having me on your show.
Now, I've attended your arguments while I was interning at the Delhi High Court, and there was this entire thermocol sheet where he was explaining how the patent works. For every person sitting in the courtroom, even though they did not know about the brief, they understood how the patent works. So with that backdrop, let's say a junior advocate is arguing before the courts and there is paucity of time. So how should that person choose what to argue before the court and what he should just leave for the written submissions?
Talking about technology and the technical side of it, I am today known as a patent litigator. I'm not a science student. I have not done biology, I have not done chemistry, I have not done physics. I've done it till the school level, very basic. Technology used to scare me. I converted that into an advantage. I don't know the technology, so when I'm sitting for a briefing, you've got to explain to me that I first understand it. And I don't understand your jargon. But a lot of words which to a technical person are second nature are not second nature to us. So as a result of that, the briefings that I needed to get for patent litigation was break it down for me. And then I would spend hours reading it and say, how can I present this in a half sensible manner? Because I know the judge also will not be, and very unlikely that the judge would be familiar with the technology. And even if he is, then for him or her to understand this technology in a rush, I have spent 6 hours or 10 hours of briefing, but I have only an hour in court. How can I make this easier for the judge to understand and be able to rule and feel confident to deal with it? So when I started the profession 20 years ago, nobody was touching patents that, this is a highly technical field. Today, every judge who comes into the IPD is excited to do patents and is writing wonderful judgments on patents. And I can tell you many of them are in my situation who may not be science students or understand that technology or have ever understood that technology, but are able to read and understand and imbibe and see what's right and what's wrong. And it's not just for patents. My style of argument is storytelling. It is about storytelling. And the other thing I noticed was I like a lot of humor in life. I don't like a serious life. So as a result of that, a lot of times breaking into a humor lightens the environment and then opens up minds. So if two parties are warring with each other, the judge is also upset, why are you both fighting? A little bit of humor helps the cause. In one of the cases, the judge said it had becoming heating up, and the judge said it's also very, warm in this room. So he looked around in the new courtrooms in the High Court, and he looked around and said, there are AC ko upar karo. So I said, if I'm not mistaken, when I walk in, I think the AC panel is right by the door where we enter. He says, it can't be on that side. I said, the temperature of the court is always controlled by the bar, never by the bench. So just a little bit of humor. In another example, during the period when there was basmati rice has been stolen by Texmati and all that, And so I appeared for a Lacoste matter before the judge, and what is this, Mr. Lall? You foreigners have taken our basmati, this, that, you Americans this, you Americans that, you steal everything. It went on for 5-10 minutes. So he said, tell me now, why should I give you protection? Because I said, simple, I'm not American, I'm French. He started laughing, ha ha ha, that's a good argument. I'll give you that order. In another case, it was on jurisdiction. And the judge heard me on jurisdiction and said, Mr. Lall, you've just got to go to Chandigarh. That's where the jurisdiction is. I can't allow this. I said, no, one last argument, if you don't mind. He says, yes, what's that? Why? He says, tell me, why don't you want to go to Chandigarh? I said, my in-laws are from there. He says, ha ha, only for that I'll issue notice, but next date I'll dismiss it. He issued notice, I served them notice, and the matter settled, and it finished in Delhi. So, you've got to understand your judge. Some judges may not appreciate humor, so then you've got to hold back. And I think a good thing for juniors to do is sit in court and observe. Law is not about age, it is about a lot of reading. So you must know diverse facts about your case. The more you read, your reflexes, like the AI, should be sharp to give answers that the judge is looking for. You can't simply go and give your own speech. And as you sit in court and watch the judge through different, you'll be amazed how differently each judge perceives a particular situation. And then you've got to think as to how will I present that case for this judge. So I don't take a briefing for a new matter till I know who the judge is. And I'll say, unless I know the judge, I can't take a briefing because I don't know what questions to ask you because we appear every day, we know what the judge is going to be asking. So we can almost today anticipate what is going to be asked. And when you anticipate, and because we get as senior counsels a brief which is already prepared, we find some mistakes, and I know this mistake will be caught by this judge, I'll go up front and say, you know what, last evening when I got briefed, I found these 2 errors, I'm putting it up there in front for you. So then the honesty comes out, the judge feels that you're on his side. And from that position, then you walk on water, because once you convince the judge you're on his side, and never let that confidence be lost. That's very critical. If the bench starts feeling that you are not on their side and you will mislead them at the shortest opportunity, you are cooked as a lawyer. So you've got to start from where the judge is. So from literally in a physical scenario, move up the bench, stand with the judge, understand what he wants to hear, shake his hand, and then start moving away from him, coming back to where you're arguing from, to now start representing your client. Once you've got the judge that, he's on my side, he will not mislead me, I don't know the brief as well as he does, but I know that I can trust him. And take him to your weak points and then to your strengths. And it's understanding another human being. And I think if I can call myself a half-successful lawyer, it is about understanding another human being. And I was extremely gregarious and outgoing, and I loved watching people. If I went somewhere, I didn't look at buildings, I looked at people. That's what it interested me. So reading minds and reading people is what helps you. And of course, a lot of reading of the law. So then you combine the two and see, the judge likes to hear this. How can I put this from the law that I have understood and to the facts of my case? Combine the three and present it in a manner, because you have very little time. So spend time on the brief, understand it thoroughly, page to page. Somebody may think these are important points, but you have to read it and make your own estimation. So knowing the judge, I change my arguments, and I think every good counsel changes his arguments and the briefing according to what the judge wants to hear.
So if I have to again summarize, firstly, storytelling, witty humor, but you have to be aware of when you're doing that. Thirdly, read your case, understand the facts. Fourth would be know thy judge. This was also something one of my senior advocate had instructed me when I was interning under him. And based on that, take a tactical call. But all of that also requires you to be seated in the court before your case and understanding what's happening in the courtroom.
Yes, so the first thing I do if I go to an outstation brief is, when is my case? It's going to be called at 12. I'll be there at 10:30. Or, put me online with that judge's cases a day before. And then you make mental notes of where the judge reacted, how. And then you so the more you see, the more you'll imbibe. You see how different lawyers handled it, what did the judge like, how did he deal with that situation. And then you put that in context of your case, really helps. But going in blind into a courtroom where you don't know the judge, I think is a very dangerous proposition for the best lawyer.
With all of these wonderful attributes, you had taken your law firm Lal and Sethi to great heights. So, for someone who wants to start a career in IPR, firstly, what are the options and beyond litigation? And secondly, I'd like to come to litigation.
IPR, essentially, the big bucks are not in the litigation. When I started my practice, and even before that, the big money was in IP prosecution, which is trademark filing, patent filing, copyright filings. A lot of work is advisory work, strategy planning, so conflicts, opposing third parties. So IP law has a lot of dimensions which are outside of court. So for somebody who doesn't like going to court, likes, a 9 to 5 job, it's possible. Second is IP is a global situation. You can't survive in IP doing work in Delhi with Delhi clients. You'll need to travel all over the country. Bangalore or Hyderabad are the tech hubs. Gujarat is for medicines and pharmaceuticals. So you've got to travel. So, and having mostly foreign clients, I traveled all over the world for conferences. You've got to be very, very gregarious. And, many of we go for this INTA conference, and many of my colleagues found it a very, coming from India, small law firms, it's a overwhelming experience. And I said, why do you go for overwhelming experiences where you're a nobody? I was a nobody, and I still am. You go for a conference, you've got a Citibank, you've got Warner Brothers, you've got Coca-Cola. Who's going to look at you coming from India, Chander Lall? Nobody cares. So get into conversations with people, not caring who they are. Make your friends so that next year you want to go back. Be interesting and learn. If you can't find people to talk to, go into sessions, learn. What is the world talking about? What is interesting? And have diverse interests so that nobody wants to shake your hand and start talking trademarks. They do that day in and day out. But if you shake your hand and say, why don't we go climb this mountain or go cycling here or go running together, it opens up a different avenue. And once he becomes friends with you, invariably he'll convert it into clients. But if he doesn't, that's also all right. I've had friends who've said, I will never give you work, but you're still my friend. I will meet you every inter. I know it's a tight schedule for you and for me, but we must make sure we meet for a meal. So that's the second aspect of it. And the third aspect is litigation. And litigation is always fun. And IP litigation, I think, is fascinating. We used to be told that it's a 2-act or 3-act. You guys only know 2 acts. One judge used to tell me that, this is not Chander procedure code. We follow the CPC in this court, and I understand you IP lawyers don't even have any understanding of the CPC, and therefore your pleadings are so poor. To now having that respect to say nobody is fighting an IP litigation today without an IP lawyer. Nobody is getting a generalist and all the good IP lawyers today who are practicing in the Delhi High Court were generalists who are now specialists, who are as good as any IP counsel. I mean, I am one of the few who came from an IP field, but I can name so many good, fabulous IP senior advocates today in our courts who were not start-outs as IP counsels, who have chosen to come into this field and doing a fabulous job. So that has its own avenue. So it is a very wide spectrum. I would say intern with a firm which only does prosecution work, intern with a firm which is very litigation heavy, definitely go out and meet people, intern with people who can engage, learn how to engage with people. Engagement will be required for your clients, engagement is required for the court, engagement is required for your colleagues. You need to be a good conversationist. To be a good conversationist, like a good AI app, you need to imbibe a lot of information. So imbibe that information, and not just law. Imbibe information around the world, and it widens your areas, your sphere of thinking. All of it helps. Law is very sort of practical and very, in your face what the world is, and it's almost intuitive. It's almost intuitive. You can see if this seems right, that must be the law. In most cases, you'll be right.
Law is ultimately made by the people to govern the people and be with the people. So be authentic about it. Have great people skills. Listen to people, learn about them, explore options, as well as, again, you talked about internship. Start slow, start strong. I'll jump now directly to the burning question. AI requires data, a lot of healthy data to produce great output. And a lot of that data is copyrighted material. You are arguing a case against OpenAI, which builds ChatGPT. So, what is your stance on this?
Well, first, let me correct you. It's not against ChatGPT. It's trying to formulate the legal principles where AI will function. AI is going to be the most disruptive technology going forward. That is the expectation, although if you've read off late, people have started, reducing the amount of effort going into and the amount of money going into AI, but it is going to be very disruptive. And like human intelligence, it is very dependent on content. It is one of the largest consumers of content because it practically consumes everything that is out there in the digital space. And it is therefore highly disruptive because in its training modules, it requires high quality content. And if you put in junk, it will give you junk. So high quality content is a prerequisite for good AI outputs. And therefore, it is a highly, heavily IP dependent system. And I certainly hope as laws develop, there's a recognition that creativity will only come from humans, and you have to compensate humans to enable them to create. And if we think that AI is going to continue to grow without human creativity, I think we are barking up the wrong tree. And therefore, we've got to understand that the creator, i.e., copyright owners, patent owners, trademark owners, now in the Getty Images case, trademarks are also coming into AIs, will have to be compensated by AI companies. And to think that it's going to be free, training material is going to be free, I don't think is the way forward. And I don't think that is where jurisprudence will head towards, though there are right now many conflicting sort of opinions coming from different parts of the world.
So, currently the courts are interpreting the laws, but ultimately it is the legislature that will lay down a regulation or the framework. Now, Japan allows complete free use of copyrighted materials, train your AI. USA uses the fair use doctrine, and EU requires disclosure of what all copyrighted material that you are using. So, for India, what approach would you suggest?
I think Japan, they're trying to pull back a little bit. They're not going all the way into allowing AI to do what it wants. The US fair use doctrine is very wide and open ended. It's very different from the fair dealing doctrine that we deal with in India or the United Kingdom or Canada or other Commonwealth jurisdictions, including Australia. So, fair dealing is more close ended. Fair use is more open ended with the four-factor test that the US Supreme Court has laid down. So, therefore, US law is more equipped to exempt AI training from a fair use exception, but their fair use exception and the four-factor tests, I must congratulate the US legislature to have taken into account, it takes into account quite beautifully AI, and I think it really is coming fast to the conclusion that it is a commercial enterprise. Yes, you do train, you may not reproduce, and the output data may not be the same, but increasingly I'm seeing US jurisprudence move towards the licensing model that you will need to license. And I think that will lead the way where we too will open up our fair dealing principles to accommodate AI, but with a licensing model. AI can't work without a licensing model. So the Japan system that they have attempted to say AI will be given a free hand is not a long-term solution.
So, would you recommend that India expands the fair dealing model and allow the AI to use a bit of copyrighted material, but based on a licensing model?
So what AI does is it converts the actual language into tokens and vectors for it to then crunch that data, and then after vectorization, it transforms the data. It's a transformative system, and then when it regurgitates it, it's different from the original data. So they seem to think that this process of training is equivalent to a human buying a book and reading it and then gurgitating material. But I think the key there is buying a book. What if a human learns from a pirated copy of a book and then regurgitates information? Yes, the output may not be infringing, but the input was infringing. You can't exempt me to go and buy one of those copyrighted books which are sort of pirated, acquire the knowledge, have a whole library of infringing copies, and then go and talk about it and say, because I'm talking out of memory, there's no infringement. Uh, so I think that same principle will have to apply to AI.
That also summarizes the position in a beautiful manner. On the topic of judiciary and interpretation, there has been a discrepancy between what was posted online and how the judges interpret that. Now, there was this recent scenario where there was a meme where someone impersonated the Chief Justice of the country and demanded some money, and in the end wrote send from my iPad. And this was supposed to be a joke, and the entire online internet community understood this was a joke because this was actually part of a larger trend. However, the Supreme Court files an FIR. So, how should the courts keep up with the social media trends? Or should they not?
So courts have to keep up with the social media trends. But I think it's interesting how to think that was simply a joke. But I know that these kind of memes have been sent and messages have been sent. I think there was an African country where these used to come. Nigeria used to send out these memes to you to say that, can you give me this much money? I am stuck. I will return the money. So there's a very thin line between what's humor and what's actually. You've seen Jamtara, and that people do make calls. You get messages for you to share OTPs, etc. So I think humor has to have its place, and because it is already such an unruly horse. The internet has been an unruly horse. Now with these new technologies of being able to WhatsApp and then AI, now deep fakes, impersonating voices, faces, photographs, morphing photographs. It's just everything is changing too quickly. So I think the generation gap is every 5 years. So to interpret, the courts can't just see the younger generation and saying, oh, this is a joke, why are you initiating an FIR? But somebody who's more the Chief Justice's age is thinking, this is absolute fraud. So you have these two extreme views. So I find it very amusing that you simply say, that was a joke, why would you initiate an FIR? And I'm like, no, that's not a joke, You guys call something really good as sick. So there's a huge generation gap there. Right? My son keeps saying, Dad, that's sick. What do you mean that's sick? Are you sick? No, that's really good. So that generation gap will happen, and courts will have to interpret it in the manner in which it is said, what was it intended to achieve. And somebody, if it was a joke, it'll get away as a joke, but it needs to be investigated. And I think that's where arguments come in. It's not the only challenge that courts have faced. It's not that judges always apply their own knowledge. They hear what they hear and then balance out what transpires and what they eventually rule.
So you are correct. Balance is key, and we must bridge this generational gap in a manner to have an equitable outcome. Now, on this topic, you have previously advised Shah Rukh Khan and a lot of Hollywood businesses on how to protect their businesses. But now with the startup, and again, these online creators, what would you recommend them to protect? Because obviously they are not educated on IPR.
2001, when I worked with Shah Rukh for his film Ashoka, or Amir with his film Dil Chahta Hai and Lagan, and they were as clueless about copyright, being part of that industry which was copyright dependent. I think today's copyright creator is far more clued in. In a way, copyright has become more necessary and important, but in a way it has become less important. When you made a film, it was your lifetime, almost lifetime of work, 4 or 5 years of work, and then you had this big release, and therefore it was dependent on recognition of copyright, because if that release got spoiled, which it always did by coming online platforms before it came on a theater, that whole film which cost you 100 crores got ruined. Today, that same film is being created for much less. Smaller films are being created almost every day. Wherever you go, there's somebody with a camera and filming something. Now, on Instagram, what is a hit today will be gone tomorrow. So by the time you think of enforcing copyrights or enforcing that right, it's become inconsequential because there is so much content coming in. So as a strategy, you've got to understand that if you are a creator, your job doesn't end with creation. You can't keep making properties and letting them be lost. So if you're a rich person, you can't keep buying cars and leaving them open in the streets so people can come and steal them. Or you start making homes and you leave your homes open so people can come and sit and squat on them. You don't do that, right? You don't buy a summer home or a winter home and then leave it open. You lock it up. Similarly, when you create IP, and you create a lot of IP, so you have a lot of cars, or in my case, bicycles, You keep them secure, you recognize what it is worth, you recognize how to keep it secure, how to lock it up, and how to exploit it. If you keep a car out locked for too long, it will get spoiled. So you've got to use it. Let the car go. Give it out to maybe a Uber or let somebody drive it so that it keeps running. It gets your revenue, and yet nobody steals it. So I think it needs it's in a podcast, I can't tell you what all is needed, but it's a recognition. You've got to understand what's in your pocket. If you don't understand what's in your pocket and the value of what's in your pocket, if you're wearing a watch, which is a very expensive watch, and you give it to somebody, my watch doesn't matter, it's an Apple watch, I could give it to somebody. But if it's an expensive watch, I have to recognize it's expensive. What is the price? And who should I give that price to? So it's exactly the same. It's a property. It's only property of the intellect. It's intangible. So you don't touch it, you don't feel it, but it's still very valuable. And because we can't touch it and feel it, I think we lose the value of it. And the copyright industry, unfortunately, seems to think at creativity, their job ends. The exploitation of that and protection of that is somebody else's job. The state should do it, the police should do it, the courts should do it, but you have to enforce it. Nobody's coming and protecting your property. So you've got to go out and protect your own property. For that, you've got to recognize what you have because it's intangible. You can't see it. You've got to have some understanding of the law. What does copyright mean? What does a patent mean? What is a trademark? What is a design? What is confidential data? What is information? What is my publicity right? How far can I go? What are the legal remedies today?
So, in a nutshell, if I have to summarize, firstly, your job does not end at creating. Create, protect, use it, enforce if someone infringes, and even if you want to give someone else to use it, license it in the manner as you explained. You would give that to.
So most important, monetize it first. Somebody comes and tells me, I have 20 patents. How many of those patents are monetized? None. You go to IITs, you go to all the technical institutions. When I used to hire from the IITs for patent drafting, they used to say, I said, how many patents do you have? What is patents? I mean, you're the premier technology institute of the country. You don't understand patents. So what do you do when some new technology comes out? We publish. What happens with publishing? Oh, my name gets more famous as a professor. Did students help you with creation? Yes. So what happens to that? We put their names as well. So does that get you any money? No, it gets us fame. So fame feeds you? No. The same thing the West was protecting, registering as patents, and protecting it. We just don't have an understanding of it. As a result, I don't think our government is fully tuned to legislate appropriately. And that is because our own owners, the rights owners, are not familiar with the subject.
On that topic, and coming to the last part of the conversation, that would be a lot of advocates complain that they do not find time for their fitness or going out. You have a stellar practice in IPR and a lot of various domains. At the same time, you are passionately following various adventure sports. You cycle to the courts. So how do you find time? And fundamentally, what does a day look like in your life?
As we grow in the profession, and I see that differentiation when I'm at my house where nobody cares a hang about me to when I go to court where everybody's serving me, we get enamored by what we get in our workspace. And as we grow, more people look up to you because, you've made a name, you've become somebody. That consumes you. You say, why would I ever leave this? This is my recognition. I make good money, I make a good name, I have a recognition in society. This is what defines me. Then what? Then your health deteriorates. That definition disappears. No matter who you are, you're gone, people forget you in a day. So I think we lose perspective. So every age has its advantages. And you've got to, it's a short life. You've got to take advantage of that age. As a youngster, you're able to travel, intern with a judge, sit here with a podcast with me. I can't do that. I don't have that time constraint. Because your time is I won't say free, but it's cheaper than my time. And if I have to make an evaluation, I'll say, my God, will I go and say, can I come to Gujarat and interview you? I'll say, no, you know what? Opportunity cost is too high. So I think you've got to balance that out. And it is absolutely essential that you always pull back from this beautiful world of law where you get this recognition to come out to be an ordinary human being. I think most people find that very difficult. I have a very close friend, I'm not going to name him. I hope he's listening into this podcast. You get so taken in by this that everything else becomes inconsequential. That's not how life works. And life is so beautiful. What is the point of having fame if you can't enjoy the life? And I used to do a lot of work for the film industry. And I started coming in the newspapers. I started getting calls from people who had no connection with me saying, would you meet me for dinner? Would you come for this party? I went for a few and said, is this how I really want to be spending my life? Every minute is precious. So you then start thinking, and everybody has time. Don't tell me that you don't have time. I could get a brief or refuse a brief, or I could shift this timing to, if I have to play tennis or squash or go cycling or go for a hike. Nothing changes. I was running a robust law practice, exclusively held by me. I was pulling the cart almost single-handedly. 2017, I left. The firm has grown exponentially with no efforts from me, with no participation from me. Was I invincible in the firm? I walked into that room, everybody called me sir, everybody was scared of me. I was the king at the firm. I had to leave it and come out and become a senior advocate with saying, who will brief this guy? He was a competitor of ours in the intellectual property field, so why will I brief him today? He may be still connected to the firm, why will I brief him today? And the rest said he knows nothing but IP. Why should I brief him at all? And I'm mindful of that situation. I said, I still have to take this plunge. And it made me a human being again, from one of the leading law firm, proprietor, senior partner, founder, to a nobody senior. And again, I was back to square one, scraping at work, saying, what, defendant brief, I'll take a smaller fee, I'll take a lousy defendant's brief. I've been a thorough plaintiff's counsel all through because I've held multinational briefs. Now I'm back to Ramu Shamu on the defendant side, trying to protect them. And I think over time I developed a reputation because, again, put in the work and said, we can't have him opposite him. And then again I said, do I really want to do this 24/7? I could get 10 briefs. Today I don't need to. If I go away, I know there are 50 other or at least 10 other better counsels than me who people can brief. They'll go away from me. Sure, I'll still go for my trek. I will take off and go, and it doesn't matter. Life still goes on. When I come back, I'm surprised. But I was the king of this area. What happened? Life went on to everybody. Nobody even knew that I was gone. So I think we give too much importance to ourselves. We've got to treat ourselves a little less important, become a little bit less important to yourself. Give yourself the importance, not what's around you. When you're, as they say, when you're lying in your deathbed, you're not going to say, my God, I wish I had gone to office one more day. You're going to say, I wish I had visited. The world is so beautiful. There's so many places to go. You talk to people, it excites you. I want to go there. You talk to a few people. If you keep talking trademark, so what do you think of trademark law? You know what? That's section 1 to 134 or 152. That's where life ends. I don't think you should end it there.
I think that's a beautiful, beautiful note with which would like to end the podcast on this note. And ladies and gentlemen, that was the well-known mark in the field of IP, senior advocate, Shri Chander Lall. Thank you very much.
Thank you very much.